Good morning, honorable members and honorable Deputy Minister.
Thanks, Chair.
I just want to verify in terms of the Select Committee who is currently present. We have not received any apologies, but we have Honorable Bartlett, Honorable Fisser, Honorable Mtetwa, Honorable Nkosi, Honorable Mikolakis, Honorable Sileku, Honorable Motsamai. I hope I haven't missed any other honorable member. But given that we didn't receive any apologies, I take it.
Sorry, you have missed me. Nita is in, but
iPad
me. iPad me.
No, thanks for that, Honorable Nita. Okay, honorable members, I think we have sufficient honorable members, more than sufficient honorable members present for us to then continue with this process. Once again, welcome, Deputy Minister. I see you are on the platform. We had invited the registrar as well, and I'm not sure if she is on the platform. But I think as we proceed, we can verify that. Our members, just in terms of our previous engagement, which happened on the 23rd of June 2021, we received a briefing from the department in terms of the 3 domestic violence bills, as we call them. These being the Criminal Law or the Sexual Offences and Related Matters Amendment Act Amendment Bill, the Criminal and Related Matters Amendment Bill, and the Domestic Violence Amendment Bill. Members, just to put it on record that we also put the bill out for public comment from the 11th June to the 16th of July. And this was also to ensure that there was sufficient time for the public and stakeholders to make public comments on the bill. We did receive a total of 87 submissions on all 3 bills, and included in the 87 submissions were 41 individual submissions via the Dear South Africa website, either indicating support for all 3 bills, no support, or not fully supporting all 3 bills. But the majority of individual submissions were in full support of the 3 bills. However, in terms of today, we'll be dealing with the Criminal Law or the Sexual Offences and Related Matters Amendment Act Amendment Bill. And in respect of this bill, honorable members, as a committee, we received 18 written submissions from individuals and organizations. And I think we should also take this opportunity to thank those individuals and organizations for these submissions. And in terms of today's meeting, we will receive the department's response to these submissions. Members would have also received all the relevant documentation in this regard. I think that being said, let me then hand over to you, Honorable Deputy Minister, to lead the process in terms of the department taking us through the departmental responses to the public comments. Honorable Deputy Minister.
Good morning, Chairperson, and good morning to the members. The department has prepared a response to all the submissions, which they will take you through shortly. I wanted to just, though, deal with 4 broader points relating to the submission. Now, these points are not being made. I mean, we have a bicameral parliament, and the NCOP has to consider this
recording
bill.
In progress.
Although it is a Section 75 bill, so the NCOP is limited to proposing amendments rather than actually being able to amend, as is the case with the Section 76 bill. So I'm not trying to undermine that process at all. I just want to stress that. But I just wanted to touch on, as I said, 4 points. The first is the issue of which came up in the submissions, the location of the National Register of Sex Offenders, and whether that a separate register should exist or whether the police register should be used. The National Assembly Portfolio Committee dealt with the issue quite extensively in terms of engaging with the Department of Justice and the police, SAPS, and the people running the Police Criminal Record Center. And so the what is in the bill is after, or what has remained in the bill is after considerable engagement. It's a complicated issue, but that was their view, but after considerable engagement on the issue. The second issue is the question of public access to the register, which I don't think, as far as I recall, was so much of an issue, but you've had submissions. The concern about making the register publicly available to everybody is twofold, really. One, we have a history of vigilantism in our country. And the fear would be that if you have a child who goes missing or a young woman who goes missing, and it's known that there's a sex offender a couple of streets down, then the chances of the community doing something bad to that person who might be completely innocent is quite big. I think across the world, it's very few countries that have their registers opened. I think it's only a few states in America. The National Assembly put in an amendment that an interested person can apply to the registrar to determine whether the particulars of any person have been included in the register. So you are able to contact the registrar to check whether a particular person you're interested in is in that register. There are some restrictions on that. The application mustn't be frivolous or vexatious. The person who submitted the application must have an interest in the disclosure of the information, and the disclosure of the information must be in the interests of an identifiable vulnerable person. But I guess so you can do that. The other aspect is that not all, whilst it's true that all cases are heard in court, even in the case of sexual offences courts, the court might be closed. The name of the accused would be known. That's not so in all cases. The name of the accused is protected where the accused is charged and then found guilty of committing a sexual offence against their own child or a stepchild, and the two identify the accused would identify the child. So those people, if those people's names are on the register, one can say whether they're on or not, but it can't be made public, because if that is the case, then it's the child who's going to suffer from that. So there are those two cases, but there was a lot of consideration given to that. The third issue, which has come up in your submissions quite a bit, is the issue of the definition of vulnerable persons. Now, if you remember, the original act just applied to people who'd committed offences against children and people with a mental disability. And the other thing to remember is the whole issue with the register is it's a restriction on employment. And if you're on the register, you cannot currently be employed to look after children or people with a mental disability because they're vulnerable. What this amendment does, has extended that so if you committed an ordinary rape against an adult, if you can call rape ordinary, maybe it's not the right word, but if a person is convicted of raping an adult, their name does not go onto the register at the moment. The amendment basically makes everybody who's committed a sexual offense, their name goes onto the register. But the whole purpose is to, the whole purpose is to restrict employment on certain people, or on people whose names are on the register. We did look at the question that's now from the department side before the bill was introduced, should we stop any person who's on the register being employed in the public service, for example? But that would be taking it quite wide, and you've also got to consider the issues of a person that's found guilty is punished, and they've then also got to be looked at having the opportunity to getting a job. So the restrictions on employment are specifically that you can't be okay, and now the categories used is not a child or person who's has a mental disability, but it's a person who's vulnerable. That has been expanded to include, as you would know in the definition. Trying to find it. Still a person who has a mental disability, but it then now is also expanded to include women under the age of 25 years who are at a higher education college, receiving vocational training, living in a building which is used primarily as a residence for such women. A person who's been cared for or sheltered in a facility that provides services to victims of crime, a person with a physical, intellectual, or sensory disability who gets community-based care or who lives in a residence for them and or is cared for in a public facility providing 24-hour care. And then it also applies to people over 60 who are also receiving care. So not every 60-year-old, but somebody who's effectively receiving care. Those are the vulnerable people. The restriction on employment is you can't work with a person who's vulnerable. You can't be in a supervisory position over a person who is vulnerable. You can't have a license to operate a business which has supervision over a person who's vulnerable. And you can't become the foster parent, kin share caregiver, temporary safe caregiver, or adopted parent of a child or a person who's mentally disabled. Who has a mental disability. That was there before. Now, so basically, the issue of the definition of vulnerable persons is linked to this issue of employment, and there are lots of other people who are vulnerable. I agree, all women are vulnerable, but it's a question of if you extend it to all women, then you're going to limit, you've got to also look at the opportunities where sex offenders, sex predators would have to sexually abuse or rape people. And you will see it's primarily looked at places where they're particularly vulnerable. A sex offender in a shop who's serving the public, really, I don't think has too much opportunity to rape a customer. It did happen with the Uyinene Mkhwetana case, but that was quite unique. So that's the logic behind this whole issue. There were requests from the LGBTI sector to be included in the vulnerable groups as a vulnerable person. But again, it's a question of are there particular situations of employment where LGBTI people are particularly vulnerable from those people being employed? So I just sort of wanted to give that as background, that it's not the definition of vulnerable person does not include all vulnerable people or people who are vulnerable from sexual abuse. It's trying to limit the situations where people are employed to work with them. The last point I wanted to make is an issue that came up subsequent to the National Assembly. I don't know if it was raised there, but is the issue of all people who have been convicted of a sexual offence in terms of the Sexual Offences Act and any other law go onto the sex offenders register. Now, when it comes to people selling and buying sex, the whole issue of decriminalization is a different topic, a different category. We hope to, once this third wave is over, be able to engage in discussions, consultations with stakeholders on the whole issue of decriminalization. For the purposes of this bill, though, it is an issue and a problem, I think, that currently the sale of sex is not restricted under the Criminal Law Sexual Offences Act, Criminal Law Sexual Offences Act. It's under the old 1957 Act or so. So that's any other law. And I do think that the people selling sex shouldn't be included on the sex offenders register because they're not sex predators. So what's the point? And it's going to affect their ability to get well. It's not part of the original keeping of the whole structure. The issue can also then be looked at. The buying of sex is criminalized under the Criminal Law Sexual Offences Act. I think it's Section 11, if I'm correct. And you'd also need to look at whether those people should be included on the NRSO, because are they sexual predators? Are they likely to sexually assault or rape somebody else? Obviously, a person buying sex, if they rape the sex worker, then that is rape anyway, and they would be convicted, and then their name would go under the on the NRSO. So, Chairperson, I just wanted to highlight those 4 broader points, and then I'd want to hand over to the DDG of Legislative Development, Ms. Kale Pillay, and her team to take you through the rest of the submissions. Thank you.
Thank you, Deputy Minister. But can I also make a request to everybody else who would be on this platform to please put on your videos when you speak? Thank you, Ms. Pillay.
Thank you, Chairperson, and good morning to the honourable members. Thank you to the Deputy Minister for the introduction and for the outline of the some of the most critical issues that affect the bill. Chairperson, unfortunately, while we would like to keep our cameras on, our bandwidth is extremely low, and it's going to affect the quality of the process of this connection today. So with your permission, after we introduce ourselves, may I request that we switch off our cameras, please?
Okay, I think that would be relatively understood given individual circumstances. Thanks.
Yes, thank you very much, Chairperson. Chairperson, today we've submitted the summary of all the comments that were received. The comments are divided into 2 tables. The first table reflects the comments of a general nature and also reflects the view of the commentators who are opposed to the bill and those who are in favor of the bill. However, I must add that the majority of the comments that were received are in favor of the bill. Chairperson, the second table of the summary is focused on providing the committee with an indication of the comments that were received that are of a more technical nature. At the outset, Chairperson, Mr. Dupriya will take us through these comments, and I must say that we do envisage that some amendments may have to be tabled for consideration. Mr. Dupriya will elaborate, and we are joined by Ms. Ntombi Machela, the National Registrar, and she's online. She will also clarify in National Register. With that being said, Chairperson, may I hand over to Mr. Dupriya.
Mr. Dupriya.
Good morning, Madam Chair, members of the committee and Deputy Minister. My name is Henk Dupriya and I'm from the Legislative Development section of the department. And with your permission, Madam Chair, I would like to stop the video feed now and share my screen so that the committee members would be able to see the summary of our submission. Thank you, Madam Chair. Madam Chair, I trust that the members can see the document on the screen. I apologize, I have to reduce the size of the document a bit so that I'm also able to read the document. Madam Chair, as my DDG indicated, Table 1 reflects comments of a general nature. And the first part of that table, we give an indication to the committee of those individuals who were opposed to the bill. I think the comments there, they are purely of a general nature, and I think it would be quite straightforward for the members of the committee simply to read them if they have not done so yet. I must admit, Madam Chair, the persons opposed to the bill were in the minority compared to the sum total of the individuals who made submissions to the committee. The second part of Table 1 then reflects the individuals who were in support of the proposed amendments. Some of them not only expressed support, but then made general comments. For example, if we look at the submission made by Al Skuma, who supports the bill, only indicate that only an accurate and up-to-date register of sexual offenders of children will be helpful and needs to be available for all. We have provided a response there, but as soon, or if I may propose, and possibly after we've gone through the two tables, if there are any practical questions that your members would like to raise, as we have indicated, the National Registrar is also on the platform, and I think it would be much more suitable for her then to answer questions relating to the practical implementation of the register. COSATU also supported the bill. The Action Society made a proposal that the pronouns he or she should be replaced with he, she, them, or they. Now, Madam Chair, this is a proposal that the department is not opposed to, but unfortunately, it means that the amendments to be effected to the Principal Act will be much wider than the ambit of the amendment bill, but that is something that will receive the necessary attention in future. Our Deputy Minister, during his introductory speech, indicated to the committee that the proposal that the National Registrar be replaced with the SAP system of the Criminal Records Centre. I don't think we need to bore you with the detail at this stage. We'll get to some of the concerns that were raised and considerations that were taken into consideration to finally decide that the registrar or the register should remain where it is. Madam Chair, I must just explain.
Mr. Dupre, we cannot hear you.
I must just explain subcommittee. Those comments are reflected in the red. For that is that we have discovered two additional submissions that were not included in the submission that was submitted to the committee midweek. But if I recall correctly, I think a supplementary summary was submitted to the committee yesterday. Once again, they raised the issue of whether the SAP system should be a system to use. Social media platforms should be used to report the alleged commission of sexual offences, and the police should be obliged, with the consent of the victim, to do an investigation into the credibility of the allegations. Now, we are of the view that the proposal entails too many unintended consequences, Madam Chair. For example, the risk of persons taking the law into their own hands, the risk of innocent persons being defamed, the risk of the identity of the of alleged child victims and possibly even child offenders being made publicly available with very little prospect of the removal of those particulars once they've been published on the public arena on social media platforms. Madam Chair, with regard to Table 2, and Table 2 now provides us an indication of the comments that we have received in respect of the specific clauses of the bill. And I'm going to, with your permission, jump right into it. Clause aims to amend Section 2 of the Act, which is the objects section. Maybe I should just interrupt myself at this stage, Madam Chair. There are many amendments contained in the bill which are actually of a consequential nature. And the amendment of Section 2G, then, the objects clause, is a very good example. As a result of the proposed amendments to Chapter 6, there are numerous provisions where merely consequential amendments will be affected to the provisions concerned. Here is an example of what the Deputy Minister also has referred to earlier, is that we have received a number of requests for the term or the definition persons who are vulnerable to be expanded or extended. In this case, for example, to include all women. Now, I think the Deputy Minister has explained to the committee that it's there's no doubt that all women are vulnerable. However, the ambit of Chapter 6 should also be taken into consideration, especially in view of the fact that we are dealing with prohibitions in respect of the employer-employee relationship. The Legal Resources Centre, they support the proposed amendment. The Active Citizens Youth, the Citizens Movement Youth Subcommittee proposed an amendment which will prevent violators of persons who are vulnerable and whose particulars are to be included in the NSRO from having any authority over persons who are vulnerable. We have merely noted the comments because it is positive and it is actually in support then of the proposed amendment. My apologies, Madam Chair. I think I'm going to cough through this whole thing today. The proposed amendment to Section 5 is also of a technical nature to the extent that, and we've explained that during our briefing to the committee, that the subsection 2 deals with the threat of being sexually violated, which will then amount to conviction of sexual assault. Now, the Law Trust Chair in Social Justice from the University of Stellenbosch, they support the proposed amendment, and we've merely noted that. With regard to the proposed amendment of Section 12, which is the section dealing with incest, most of the commentators, the Action Society and the Law Trust Chair in Social Justice, support the proposed amendment. The Legal Resources Centre expressed their concern that children do not receive immunity from prosecution where a child may have been groomed over a long time and then consents to the sexual act. Now, Madam Chair, we would like to merely indicate to you at this stage that sufficient provision has been made to protect children under these circumstances, especially with reference to the amendment or Section 56 of the Act. And I might also add that Section 12 in itself provides that if there is a circumstance where a prosecution must be instituted against child, only the National Director of Public Prosecutions may take that decision. So there was safety mechanisms built in precisely to prevent what was expressed, or the concern that was expressed by the Legal Resources Centre. The Active Citizens Movement Youth Subcommittee, they recommend that if an adult is found guilty of incest, then they should also be found guilty of a second sexual offence. We are actually, or the department is of the view that it's not necessary to introduce a provision of this nature. The adult person could always be convicted of a more serious offence, for example, rape, or even the statutory sexual assault or statutory rape of a child, depending on the age of the child. Clause 4 aims to introduce a new section in the Act dealing with sexual intimidation. The chair will recall that the committee has also, that the department has also at length during its briefing to the committee explained to the committee members what the nature and content of the proposed provision is. The Law Trust Chair in Social Justice supports the proposed new section, but objected against the inclusion of the phrase imminent, and raises the question, how should a victim then determine whether harm is imminent or not? Now, the imminent requirement, Madam Chair, is a requirement of the common law offence of assault. And the proposed new offence of sexual intimidation is based on the common law offence, but not strictly speaking the common law offence of assault, but then the offence that was introduced in section 5(2), which deals with threats. And you will recall that the bill aims to then delete section 5(2) and replace it with this wider provision dealing with sexual intimidation. The Legal Resources Centre, they support the proposed amendment, and then the Sisonke International Sex Worker Movement indicated that the provision is regarded to be of the benefit to sex workers who have been victims of acts of intimidation. The feasibility of the provision is questioned in view of the criminalisation of sex work as a sex offence. And I think the Minister, the Deputy Minister, has also touched on this, and I don't think I need to really add anything else apart from what we stated there and what the Deputy Minister has stated. Now, Madam Chair, before I get to the next part of the table, I would just like to maybe repeat what our Deputy Minister has said, and maybe to explain to the committee members that there are certain technical aspects that one should take into consideration when we look at the proposed amendment of Chapter 6 of the Act. First of all, the very important aspect is that currently only persons who have been convicted of sexual offences against children and persons with mental disabilities, their particulars will be included in the register. Now, the proposed extension of Chapter 6 in this regard, with specific reference to the type of sexual offences, entails that a person who has been convicted of any sexual offence will in future, their particulars will be included in the NRSO, my apologies. So that is the one aspect. But the other important definition is then a person who is vulnerable. Now, the aim of Chapter 6 is to prohibit certain persons currently from working with or having supervisory powers over children and persons with mental disabilities. The extension or the introduction of the definition of person who is vulnerable would mean that persons who have been convicted of any sexual offense will be prevented from working with or having supervisory powers over the list of the persons reflected under the definition of person who is vulnerable. Our Deputy Minister has recapped this morning on the content of that definition. So it's not really necessary to repeat what our Deputy has said. Madam Chair, my apologies. I apologize, Madam Chair. The definition of sexual offence consists of a Part A and a Part B. Part A deals with those offences which are currently catered for in Chapter 6 of the Act, the Principal Act, and that relates to the offences, sexual offences that was committed against children or persons with mental disabilities. Part B is the important part to the extent that this is actually where the ambit now will be extended to include a reference to all offences being committed by any person, irrespective of whether it was committed against a child or a person with a mental disability. Now, I would like to get to the comments that we've received, Madam Chair. You will note that some of them are going to become repetitive. So I think where necessary, I will not repeat what the committee has taken note of during the course of our presentation. The Centre for Child Law argues for an extension of the definition of a person who's vulnerable. Now, Madam Chair, we would merely like to indicate at this stage that extending the definition will throw the net, in other words, the ambit of Chapter 6 very wide, and will give rise to difficulties in the implementation of the provisions thereof. Extending the definition may also give rise to unintended consequences, whereby employers might become reluctant to employ certain categories of persons. And then the categories of persons who have been identified for inclusion in the definition are really regarded as those persons who are more vulnerable than others. The whole issue of the SAPS Criminal Record Centre was also highlighted by the Centre of Child Law for Child Law. I don't think it is really necessary at this stage to provide you with all the relevant detail, and I think this is something that might come back during the discussions of the committee when the committee deliberate on the bill. The concern also expressed by the Centre for Child Law is that with regard to the definition of sexual offence, they argue that the definition opens the door to increase the amount of historical data to be included in the National Register for Sex Offenders. However, Madam Chair, we would like to indicate to the committee, and I think that is also something that we will be called upon to explain to the committee again when the committee deliberate on the bill, is that care was taken, especially with reference to paragraph B of the definition, that that paragraph will only apply prospectively and not retrospectively. In other words, that would not amount to the fact that it opens the door for an increase in the amount of historical data to be included in our SO, and so that is strictly speaking not a concern. The Law Trust Chair in Social Justice supports the amendments contained in Section 40, which is our definition section. They do express the concern that they find the phrase person is vulnerable problematic to the extent that the categories of persons who are vulnerable is much larger than defined in the proposed definition. Our Deputy Minister has indicated to the committee earlier this morning that that is in fact so. However, one should take into consideration that we are dealing with restrictions in terms of Chapter 6 on the employer-employee relationship. They also recommend that the Act should clarify who in institutions of higher learning should have the responsibility to report sexual offences. We would like to merely indicate to the committee at this stage that the obligation to report sexual offences is contained in Section 54 of the Principal Act. However, we are of the view, or the department is of the view, that it remains the prerogative of any employer to implement systems and procedures in order to ensure that Section 54 is then complied with. Once again, the highlight was with regard to that all females are vulnerable and that also members of the LGBTQIA+ community are also vulnerable. That cannot be disputed, Madam Chair, but once again, with that, at the conundrum that we are talking about, or the implications of Chapter 6 means that it places restrictions on the employer-employee relationship. This is also, to a large extent, a repetition of a previous comment by the Sex Workers Education and Advocacy Task Force, SWET, expressed the concern that the NRSO applies retrospectively and prospectively. Sex workers who have been found guilty of any sex work-related offence in the past could find themselves on the register regardless of whether they still work in the industry or not. We would like to merely indicate at this stage, Madam Chair, that the definition of sexual offence aims to accommodate the proposed extension of the ambit of Chapter 6. Currently, Chapter 6 only applies in respect of persons who have been convicted of sexual offences against children and persons who are mentally disabled. Now, since the ambit of Chapter 6 is to be extended to include particulars of persons who have been convicted of any sexual offence, care was taken to ensure that the proposed paragraph B of the definition of sexual offence is only applied prospectively. Now, Madam Chair, what we would like to indicate, and we'll get to one or two more comments that we received where concern was expressed with regard to the position of persons who sell sex and persons who buy sex. And we would like to indicate to the committee that we have had a real look at the definition, but the definition read with Section 50 of the Act, which deals with prohibition. And we have realized that there might be some interpretational problems, and in view thereof, the department would like, when the committee starts deliberating on the bill, to possibly propose an amendment which could then address the concern. The Legal Resources Centre expressed the concern that the inclusion of females under the age of 25 in the definition of persons who are vulnerable will not pass constitutional muster because it differentiates between women who are in a higher education institute and those who are not. It also differentiates between women who are under the age of 25 and those who are not. And it may be interpreted as doing harm to the movement for equal rights for women. The department would like to indicate to the committee at this stage that females who are under the age of 25 and find themselves in an educational institution were identified as particularly vulnerable to becoming victims of sexual offences, especially in view of past incidences at educational institutions. The Legal Resources Centre supports the definition of sexual offence. The Sisonke National Sex Worker Movement, so far as the definition of sexual offence is concerned, the concern was expressed that sex workers who have been convicted under the 57 Act will be included in the list of those who will be added to the register and will be unable to work with children or, for example, even adopt children or work with any vulnerable person. We would merely like to indicate to the committee at this stage that it is submitted that the provisions apply equally to all persons who have been convicted of sexual offences that have been committed against children or persons who are mentally disabled. We must remember, Madam Chair, when we talk about sexual offences, the proposed definition differentiates in paragraph A and paragraph B. Paragraph A dealing with sexual offences against children, and then paragraph B dealing with sexual offences going forward, all sexual offences and not only those committed against children or persons with mental disabilities. Now, Madam Chair, we would like to merely just highlight to the committee at this stage, the request is here, or the proposal here is that sex work should be decriminalised. However, the proposed decriminalisation of the sex work or the suggestion unfortunately falls beyond the ambit of this amendment bill and is, of course, a matter that will require separate consideration. The Post Office to Parliament task team, with regard to the definition of persons who are vulnerable, once again highlights the fact that there are numerous groups of people who can be considered equally or even more vulnerable than those stipulated in terms of our definition. They also highlight that females are not only people who experience sexual violence in tertiary education, and then they also highlight the position of members of the LGBTQIA+ community. The Sonke Gender Justice recommends that the age restriction of 25 for females should be removed and that all women should be regarded as persons who are vulnerable. Now, once again, we would like to really highlight to the committee that extending the ambit of Chapter 6 too wide will give rise to concerns regarding the implementation of the provisions concerned and will even have a negative impact on the efficacy of the register system. This is the Sonke Gender Justice also recommends that with regard to the definition of sexual offence, read with Section 50 of the Principal Act, it should be clarified that sex workers are not included within the ambit of the definition. Madam Chair, I will not bore you with the detail of our response, merely to say that the department concedes that there is a concern with regard to reading the definition of sexual offence with Section 50 of the Act, and we would like to then submit a proposal in this regard to the committee during its deliberations. The Active Citizens Movement, the Youth Subcommittee, in connection with the definition of persons who are vulnerable, they recommend or they express the view that the definition is limited to persons who are mentally disabled and recommends that the definition should be extended to include all disabilities, including physical disabilities. Now, Madam Chair, we would merely indicate to the committee at this stage that paragraph B of the proposed definition of vulnerable persons do make provision for persons with physical, intellectual, or sensory disabilities who receive care in care facilities. I think then paragraph A, the proposal there, is covered by our paragraph D of the definition of person who is vulnerable. The Active Citizens Movement is also of the view that reference to youth, i.e. persons between the ages of 18 and 35 should be included because any youthful person is vulnerable to sexual offences. Once again, the concern with regard to the extension of the ambit of Chapter 6 too widely will give rise to difficulties in the implementation of the provisions thereof. We once again have the proposal that members of the LGBTQIA+ community should be included in the definition of vulnerable persons. And then finally, under this provision, they recommended that all elderly people should be included due to their physical, mental, and financial degradation. The department would like to point out to the committee that extending the ambit of the definition to include all elderly persons will once again throw the net too wide. It was decided to only focus on elderly persons who are cared for in certain facilities because they are considered to be particularly vulnerable compared to their self-reliant counterparts. The Triangle Project was the second submission that we discovered after we submitted our first summary or our final summary to the committee. Once again, they echo the proposal that members of the LGBTQI+ community should be included in the definition of person who is vulnerable. And then they also echo the proposal that we've already covered, that there should be clarity with regard to the definition of sexual offence read with Section 50 of the Act. The proposed amendment of Section 40 then, which deals with the prohibition on certain types of employment of persons who have been convicted of sexual offences. The commentators there, the MEC Social Development of the Western Cape, indicated that the ambit of the proposed amendment is too wide and will include scenarios where, for example, persons who work in shopping malls, where young persons congregate or are present, will have to be vetted against the NSRO. Now, Madam Chair, we would like to indicate to the committee that that was a concern that the department had from the start when the department started looking at these proposed amendments, and that was taken care of, or the concern was taken care of, to omit the words present or congregate. In other words, to restrict that very, very wide ambit of the particular. The Law Trust Chair in Social Justice, they support the proposed amendment. The Legal Resources Centre as well. And then the Sonke Gender Justice expressed the concern that Section 41 does not include volunteers or members of the clergy, and recommends that members of the clergy should expressly be provided for. Now, Madam Chair, if we look at the provisions of that section 41, and especially with regard to paragraph B thereof, the department is of the view that the use of the words in any other manner places him or her in a position of authority, supervision, or care of a person who is vulnerable is wide enough to include volunteers and members of the clergy. The South African Human Rights Commission, I apologize, there's just a spelling error, recommends that the phrase persons with mental disabilities should rather be used and not persons who are mentally disabled. Madam Chair, we would like to indicate to the committee that this might be a second proposal that the department would like to submit to the committee during its deliberations. Although a person who is mentally disabled, that term is defined in section 1 of the Principal Act. The department is still not opposed to considering whether it's possible, and at this stage it would appear so, that the definition or the term, wherever it appears, primarily then, of course, in the definition of person who is vulnerable, to align it with the proposal by the South African Human Rights Commission that one should rather refer to persons with mental disabilities. The proposed new sections 44B and 44C, they deal with the access to the register by the National Commissioner of SAPS, and then also the obligation of the Director General of Home Affairs and Registrar was concerned about resources allocated to the administration of the register and the impact thereof on its effectiveness. Madam Chair, as I indicated, the registrar is present today, and I think possibly we could, the members, if there are practical questions they would like to raise with the registrar, we could do so after we've run through the summary. But we were present at meetings with the portfolio committee, and the registrar indicated to the portfolio committee that the registrar is being capacitated, among others, by human capital and human resources. But I think she would be in a better position to provide us with an indication in that regard. The Centre for Child Law also expressed the view that the register does not protect vulnerable persons, and is of the view that the SAPS Criminal Record Centre is a much more effective system because it provides for a person's full criminal history. The Deputy Minister has explained to us, or the committee this morning, among others, why the decision was taken to retain the register, and the department also gave the committee some of the issues that were taken into consideration in that regard. Once again, I think the registrar might be in a better position to explain to us precisely what is the impact on at ground level. And then they've also expressed the concern, or they complained, that the centre was unable for a period of 5 years to obtain accurate information on child offenders whose particulars have been included in the register. And we would like to indicate, and once again, the registrar will be in a better position to explain, but these issues have been addressed following court action that was taken in 2014. The NEC Social Development, this is very technical, Madam Chair, but they indicated that reference to section 15A in our proposed new section 54B is not entirely correct, to the extent that that section 15A has not yet been commenced. And they propose that the commencement date of section 44 should be aligned to that of section 15A. we indicate to the committee, and as I indicated, this is very technical, but it's not necessary to introduce a special provision in this regard because the proposed new section 44B power afforded to the Commissioner will only become enforceable once that section has commenced. The Law Trust Chair in Social Justice and the Legal Resources Centre expressed their support for the proposed new sections 44B and 44C. The proposed amendment of section 42 then, Madam Chair, and section 42 deals with the establishment of the National Register and the designation of the registrar. We have also explained the content of this provision to the committee during our briefing. The Centre for Child Law says that there is no clarity on how a decision will be made whether an application is frivolous or vexatious, and on what basis will the registrar decide whether the person has an interest in the matter. And we would like to indicate to the committee at this stage that it will be required in terms of the regulations to be prepared under the amended Principal Act for a person to declare the nature of his or her interest, and then it is also submitted that such declaration will assist the registrar to determine whether an application is frivolous or vexatious. The Law Trust Chair and Social Justice, they supported the proposed amendments, and then also the National Sex Worker Movement supports the proposed amendment that the register should not be made publicly available. The Post Office to Parliament Task Team is of the view that subsection 5 must be redrafted to widen the scope of persons who may apply to the register and allow for such applications to be made in the public interest. The concern by the department at this stage is that in this context, the phrase public interest might be too vague, and it might lead to confusion as to who will be allowed to submit applications to the registrar. The Sonke Gender Justice also supports the proposed amendment. The South African Human Rights Commission recommends that the registrar of the register should be required to ensure consistency with the National Child Protection Register and the Older Persons Register. And we would merely like to indicate to the committee at this stage that the content and objects of the registers differ drastically, and it's therefore not clear what useful purpose the proposal will serve. The proposed amendment of section 43 then of the Act, the Law Trust Chair in Social Justice and the Legal Resources Centre both support the proposed amendment. Clause 9 deals with the amendment of section 44, which is once again one of those consequential amendments that I've explained to the Chair earlier this morning. And the Law Trust Centre support the proposed amendment. However, the South African Human Rights Commission recommended that provision should be made for the Departments of Basic Education, Social Development, and Women and Youth, older persons, to be allowed direct access to the register. Concerning this regard, Madam Chair, is that the database of the application base, primarily by potential employees, the concern is that the integrity of the database could be compromised, negatively affected if too many persons or institutions have direct and unrestricted access to the register. With regard to the proposed proposed amendment of section 45, which gives the obligations of employers in respect of employees. The Law Trust Chair in Social Justice supports the proposed amendment. And then Sweat indicated that his own employees would be at risk if they were found guilty of sexual offences. They would not be able to work for Sweat in any capacity that involves supporting fellow sex workers. We have indicated to the committee that the key for the answer to this concern is reference to paragraph A of the definition of sexual offences, which restricts the meaning of that paragraph or the ambit of that paragraph to only persons who have been convicted of sexual offences against children or persons with mental disabilities. The Legal Resources Centre expressed their support for the proposed amendment, but then indicated that they are concerned that the Principal Act is silent on what happens to a person who reoffends after his or her particulars have been removed from the register. Now, Madam Chair, the Department is of the view that the Principal Act is clear and unambiguous to the extent that the particulars of a person which is found guilty of a sexual offence, even after his or her particulars have been removed from the register, must be included in the register and is therefore prohibited from working with persons who are vulnerable. The amendment of section 46, which deals with the obligations of employees, are also merely consequential in nature, and the Law Trust Chair in Social Justice as well as the Legal Resources Centre support the proposed amendment. A similar consequential amendment is found in the proposed amendment of section 47 of the Principal Act, which deals with the obligations in respect of licence applications. What we would like to point out, Madam Chair, is the Law Trust Chair in Social Justice and the Legal Resources Centre, they support the proposed amendment. However, the NEC Social Development of Western Cape recommended that section 47(1) should also be amended to remove the reference to children or persons who are mentally disabled. Now, Madam Chair, the department will double and triple check this, but it is considered at this stage that section 47(1) should also be amended by the removal of reference to children and persons who are mentally disabled. And the department would also like them to present proposals to the Select Committee for consideration during its deliberations on the bill. The Law Trust Chair in Social Justice as well as the Legal Resources Centre expressed their concern for the proposed amendments of sections 48 to 53. Clause 17 deals with the substitution of section 51 of the Principal Act, and section 51 deals with the removal of particulars from the register. The SWET indicated that the proposed amendments will apply to sex workers. The sentence of between 6 to 18 months to see a sex worker placed on the register for a period of 20 years. This would create huge hardship and for the individuals involved. It is submitted that the provisions apply equally to all persons who have been convicted of sexual offences. At this stage, Madam Chair, of course, sexual offences that have been committed against children or persons who are mentally disabled. And it will be difficult to create exceptions in that regard. Mr. A. Phillips recommends that the person's particulars must be removed from the register after a period of 20 years. Now, the committee will remember that the different periods, namely the periods of 20, 14 and 10 years are linked to the severity of the offences concerned, and it is submitted that those periods are just, it should be kept in mind that because of a person who was convicted of 2 or more sexual offences may never be removed from the register, and the legislature views sexual offences in a very serious light and has decided to increase the protection afforded by the register by, among others, extending the periods in respect of which a person's particulars must remain on the register. Mr. Brewer expressed a similar concern. The Active Citizens Movement Subcommittee recommends that the particulars of persons who commit 2 or more sexual offences against persons who are vulnerable should not be removed from the register because such persons show an inability to rehabilitate and they are a threat to society. Madam Chair, this is also a very technical proposal, but it's not supported by the department because to insert the proposed amendment would result in the fact that persons who have been convicted of 2 or more sexual offences against any other person, and not only a person who is vulnerable, will not fall under the prohibition. In other words, they would not fall under the prohibition of not being able to have their particulars removed from the register. Clause 19 deals with the substitution of Section 54 of the Act. Section 54 reflects the obligation to report the commission of sexual offences. Currently, to report sexual offences that have been committed against children or persons with mental disabilities. The ambit of this provision will now be extended, or it's proposed to be extended, to include an obligation in respect of all vulnerable persons. The Board Trust Chair in Social Justice raises the concern that the reporting obligation only applies to natural persons and not juristic persons. The department indicated that it's difficult to determine what useful purpose such an obligation will serve. It is submitted that it is sufficient to restrict the obligation to natural persons. Tertiary institutions are at liberty to introduce procedures and policies that are aimed at ensuring compliance with the obligation. Also, the Law Trust Chair in Social Justice also expressed the concern that the provision takes away the initiative by the complainant to report the crime. The department would like to indicate to the committee at this stage that sexual offences are viewed in a very serious light, and the introduction of the obligation is regarded as another mechanism that is aimed at protecting vulnerable persons who in many instances are not able to act in their own interest. And then finally, the Law Trust Chair indicated that provision can have some implications with regard to the victim's right to privacy. The question is raised whether the victim who refuses to testify could be prosecuted for contempt of court. We would like to indicate to the committee at this stage that it is doubtful in view of the National Prosecuting Authority's prerogative to decide whether or not to institute prosecution. Whether a person who refuses to proceed with a criminal case will be prosecuted for contempt of court. And in this regard, I would like to maybe add, Madam Chair, that it should be taken into consideration that an adult person is allowed to withdraw a complaint at any stage, and the prosecuting authority or the prosecutor can also at any stage during the proceedings withdraw a charge before the accused person has pleaded. If an accused person has pleaded and the witness becomes hesitant to testify, the first step that the prosecutor will take in the majority of the instances is to persuade the victim to testify in court because sexual offences are particularly of a serious nature, and it is in the public interest for those offenders to be prosecuted. And then once again, we get the notion expressed by the Legal Resources Centre, where they express their concern with regard to the inclusion of females under the age of 25 years and persons who are older than 60. That will have a negative impact on their autonomy and privacy. And we would like to indicate to the committee that the concept, persons who are vulnerable, should be understood in the correct context. The inclusion of, for example, females under the age of 25 years does not impact on the autonomy of privacy. The definition merely identifies a group of persons in respect of whom others have an obligation to report offences having been committed against them. The Post Office to Parliament task team also expressed a similar concern with regard to the autonomy of adult persons, where there is an obligation to report the commission of sexual offences against them. And I think it might be useful for the Select Committee, Madam Chair, to merely note at this stage that sexual offences are viewed in a very serious light, and the introduction of the obligation is regarded as another mechanism that is aimed at protecting vulnerable persons. In many instances are not able to act in their own interest. And then finally, with regard to the short title of the amendment bill, the NEC, the Social Development Western Cape, and the Legal Resources Centre recommended that the short title is too long and that it should be clarified because it can cause confusion. However, Madam Chair, in short, or the short answer is, if you have an amendment bill which exclusively introduces amendments to one principal act only, then that amendment bill unfortunately has to follow the principal act short title, and that is why we have this odd title of criminal law, and then in brackets sexual offences and related matters, close brackets, amendment act, amendment bill. That is unfortunately just one of those things. Madam Chair, and with that, I would like to maybe indicate to the committee that we are finished with the summary. I'll just go to the top of the summary document again.
Yeah, thank you very much, Mr. Dupree. Deputy Minister, do you want to make a closing remark?
Chair, no. We do have Ms. Machile, the registrar, on the platform as well. I don't know if you want her to make any input now, or if there are specific questions, or wait for specific questions.
I think we'll deal with the specific questions and our comments from members. But then let me then just thank you, Deputy Minister, and the department for your responses to the written submissions made on the bill. And I'm going to open it up for honorable members to give me an indication if you have any comment and or question that you would want to ask. Can I get an indication from honorable members if you would want to make any comment at this point in time? Okay, I'm not seeing any hands, but you could just indicate to me if you're unable to raise your hand if you have a comment. But maybe, honorable members? Okay, maybe then just from my side, Deputy Minister, I think that some of the issues that do emanate from the submissions. Some of this were also dealt with in our previous deliberations with the department. I think that was in the last meeting that we had, especially around the National Register for Sexual Offences, the categories of vulnerability with reference to the LGBTQI, the age of vulnerability, that is the 25 years, the inclusion of sexual intimidation and the reporting of sexual offences, amongst others. I think these were some of our deliberations that we did engage with you previously, and you did provide us with some clarity on these matters. I see Honourable Dodovo, your hand is up, so let me recognize you. Honourable Dodovo, you're on the platform.
Yes, thank you very much, Honourable Chair. I had raised my hand when you kept on saying where are the people, and you wanted our contributions. And thank you very much for the opportunity. Firstly, let me welcome the presentations. Very, very good. And what makes me excited is how at all material times we trying to tighten up this Amendment Act. For me, this is quite important because at the end of the day, if we succeed in reducing the acts of sexual offences in our country, it can go a long way in terms of helping our society to transform to become what we want it to be. Now, in this presentation, Honourable Chair, there is a matter that came up very, very strongly. That relates to the fact that the victims suffer from trauma. They also suffer from prejudices in terms of how people judge them, and even to an extent that there are people who discourage the victims to report the sexual offences. And for me, this is quite important because we need to deal not only with the perpetrators, we need to also identify and say it is a criminal offense for any other person, even though you are not the perpetrator, who tries to stop, who try to manipulate, who try to even give out some gratification in the form of bribery, in the form of money to a victim, because there are those instances which arise whereby some people are trying their level best to give some compensation to the victims so that the victims must not report what would have happened at that particular time. And I don't hear the presenter saying, in terms of the generality of this act, this is how far we can go to ensure that even those, in case that we are able to identify those particular people, we are able to deal with them. That's the first point, Chair, that I want to bring forward, and maybe some clarity in that respect will be quite necessary. The second one, Chair, relates to the sexual grooming. And I understand that this is instances where in which a person educates, trains, show the victim, especially children, and they abuse them, or at a later stage, they find themselves abused by these particular people. And for me, what I didn't catch very clearly, it is the time period, if it is stipulated in terms of at what point does this end. For me, that clarity is quite important, and I'm sure some of the presenters can talk about that a bit. And that, of course, relates to child pornography, which has become a serious matter in our country. The last one relates to this matter that keeps on coming, and I think largely the focus of this presentation was also around the register. And you know, saying it that we have a register is one thing, but on the other hand, the sensitivities and the confidentiality of this register for me is quite important. And just asking this question loosely, how safe will this register be? And maybe the registrar can talk a bit about it so that we are then exposed to know the safeguards in respect of the register, because this is a sensitive matter. It will impugn on the rights of the people, whether you are a victim or you are a perpetrator, and we need to be at all material times safeguard the register itself. And for me, what are those safeguards? That's my question. What are those safeguards to ensure that at all material times this register is safe and is protected? Thank you very much, Chairperson, with that.
Thank you very much, Honorable Dodo. Any other honorable member? Okay. I think as I was saying earlier, just a few comments from my side. I think that expanding the scope of the National Register for Sex Offenders is a very important aspect, because by including their particulars in the register will actually prohibit them from working with or having access to children or persons who are mentally disabled. And this will go a long way in terms of protecting children and people who are mentally disabled. And I think also as part of processing this bill, it was indicated by Deputy Minister, and as well as in terms of the comments or responses by the department, that with regard to the National Register for Sexual Offenders and the capacity of the registrar around this matter, that there have been extensive engagements between the portfolio committee as well as the registrar. And there has been also indications to the portfolio committee in terms of the capacity issues, but also in terms of this presentation that the National Registrar is looking into the issues around its capacity so that they become fully functional and that they add additional staff members. There's just another issue raised in this presentation by the Center for Child Law, where they raise a complaint that the center is unable for a period of 5 years to obtain accurate information on child offenders whose particulars have been included in the National Register. And I think in terms of a response, what comes forward is that the issues that have been addressed following a court action in 2014, but perhaps it could just give us expanded bit in terms of the issue and provide us with more clarity on this matter. And I think also that I can't agree more that with the increased periods for which sex offenders particulars must remain on the National Register before they can be removed. I think it's very important that this increased period is effected because I think, and I want to agree, that we do view sexual offences in a very serious light. The issue raised by the Human Rights Commission around the phrase persons with mental disabilities should rather be used and not persons who are mentally disabled. And I think maybe perhaps this is a matter that we should be looking at, because I think at all times when we do deal with terminology, we should be very sensitive to the issue at hand. And I think we should also, our humanity needs to also kick in terms of how we refer to people with disabilities. And then finally, I think the issue around sex work and the decriminalization of sex work. I think, Deputy Minister, your input has covered me to a large extent. While I want to agree that the issue of sex work does fall beyond the ambit of the amendment bill. But just the fact that we are also, it has been raised, Deputy Minister, perhaps this should also be a matter that we as a select committee also discuss with the portfolio committee. And I think that there should be a more concrete plan as well as commitment in terms of dealing with the decriminalization of sex work. I think those are just some of the comments from my side. Let me then hand over to you, Deputy Minister. I don't think there's any other member on the platform that would want to say something. But let me then hand over to you, Deputy Minister, to perhaps comment and or respond to some of the issues. And you can also hand over to the registrar when you speak. Thank you, Deputy Minister.
Yeah, thanks, Chairperson. I'd like to ask Mr. du Preez and Ms. Majita to respond to the issues raised.
Chairperson, my apologies, but Mr. du Preez has just been kicked out. He's trying to log in again.
Okay, thanks, Gershon. Then Mayor Majila, if you could perhaps take the platform. Gershon? I see Mr. du Preez is with us.
I'll just follow up with Ms. Majila, Chair.
Okay. Mr. du Preez?
Madam Chair, yes, thank you. I'm back, and I must apologize. Yes, ma'am. I'm back. Thank you very much, Madam Chair. I lost some of the questions and comments that were raised, but I will respond to the questions that I heard, and that was raised by a first member. The first question that he raised dealing with the intimidation of victims not laying complaints. The short answer to that is that it's not strictly speaking necessary to create a new statutory offence, but that one could even look at offences that are being committed in this regard as the obstruction of justice. The question that was raised with regard to sexual grooming, I didn't hear the question that well, but I assume that it relates to the offence of incest, and I did pick up that the question was raised with regard to time constraints in that regard. Deliberations on the bill, and especially when the committee looks at section or clause 20 of the bill, which is proposed amendment of section 56 of the Act, which and I'm really going to quote it to you at this stage, and I think it will become clear with regard to the question dealing with time constraints. But a person may not be convicted of an offence in terms of section 12. Now, here, strictly speaking, we're talking about the child in that incestuous position. A person may not be convicted of an offence in terms of section 12 if, at the time when the sexual act was first committed, the person was under the age of 18 years and other person exercised power or authority over that person, or that a relationship of trust existed between them. So that will make provision for the concern that was expressed, or the question that was raised. And that is something that was included in the Act when the original bill was approved by Parliament. So the whole issue of children being manipulated and groomed to eventually consent to certain sexual acts was a concern that weighed heavily on the legislature's mind from the beginning, when the relevant legislation was formulated. The proposed amendment reflected in the bill merely also aims to, or is of a consequential nature. Madam Chair, I must apologize. That is unfortunately what I heard from what has been said. I also picked up that there's a question which was directed to the registrar, and I don't know whether she is back on the platform. And then I could possibly then hand over to her to respond to that question regarding the safeguards in connection with confidentiality. Thank you, Madam Chair.
Good morning, Madam Chair.
Good morning, Ma'am Ajila.
Oh, thank you. Good morning, Deputy Minister, and thank you. Good morning to the honorable members. On the question on how the NRSO is safeguarded, or the confidentiality, how is it safeguarded? As we have alluded before in the presentation, that the National Register for Sex Offenders is held in a confidential manner, and only the registrar and people who are reporting under her or him have the access to the register, and disclosure of any information that is contained in the register in the exercise and function and administration of his or her duties cannot be disclosed in any way, manner or form to anyone. So this is how the National Register for Sex Offenders is safeguarded. Like no any other person can access the register except the registrar and the people that report under him or her. And there was another question again by Madam Chair on, the expansion on the complaint that the Center for Child Law was unable for 5 years to obtain information on child offenders whose particulars have been included in the register. Our response is in this function that when Section 50 of the Principal Act was declared inconsistent with the Constitution and invalid to the extent that it unjustifiably limits the rights of child sex offenders to have their best interests considered of paramount importance. The department was directed by the Constitutional Court to say on the 30th of July, 2014, to furnish a report to the Registrar of the Constitutional Court setting out the following: that the number of persons whose particulars were included in the National Register for Sex Offenders by virtue of Section 50 who were younger than 18 at the time, we should identify those details. The court also directed that their particulars be so listed, which we have done, and the dates on which the orders in questions were made was also included. This information was subsequently handed to the Constitutional Court on the date mentioned, the 30th of June, 2014. And because of the confidentiality of information contained in the register, the Constitutional Court ordered that the department furnish the details in question. And then this was done in the exercise of the court's wide jurisdiction to make an order that is just and equitable. Then, excuse me, the court then undertook to in turn make the information available to persons or organizations seeking to assist those child offenders. This obviously included Legal Aid South Africa as well as the Center for Child Law. So it is not clear why they then came back and said we did not fully comply with the requirements of the court order, because what we did not do or include was the information about the age at the commission of the offense, which they requested for after the order was made. So unfortunately, that information that we have provided was directly extracted from the register as is, and this was explained to the court why we were unable to provide the court with the information relating to the age of that particular person at the commission of the offense, because we do not keep the age of an offender when they commit an offense. So in terms of Regulation 14 of the Act, the register must contain the following, the particulars which are referred to in terms of Section 49B, Roman figure 1 to Roman figure 7, which is the name of the person, the ID number, if it is available, the court that then makes that particular order, the place of conviction, whether or not the person who was violated was a child or a person who is mentally disabled. And then the Act also provides that we must put any other particulars as may be prescribed by regulation, which in this instance, we have included a fingerprint, because a fingerprint was not part of the details that we're collating. So the fingerprint, because we have seen that it connects us, and it also connects the perpetrator to the Criminal Record Center, we have decided to say, let us include the fingerprint number of every person who is contemplated in the Act. So this means that the composition of the register is made in terms of Section 49, and how the register will look similar to what the Act requires. So in as far as we are concerned, we have submitted the information that they have requested, and we have provided them with every detail that they required. Thank you, Madam Chair.
Thank you, Ms. Majila. Deputy Minister?
Chair, I see you've got a hand, or it's gone. I saw a hand from Mr. Mtetwa.
Okay, no, let me take the hand, and also any follow-up, if there are any follow-ups. Honorable Mtetwa, you have the platform.
Yeah, thank you so much, Chairperson. I raised my hand longer. I think my system was failing me here. My network's not good. I'm not sure whether I'm audible enough.
Mtetwa, please continue.
Yes, and I apologize for not switching on my video because of the network. Chair, this sex offenders cases, most of the time, after all the hard work that has been done by the subs and the judges, especially my concern is when those that are committing such crimes, and you find that they are close relative to each other, they end up being withdrawing some of these charges. And I don't know how is it going to impact in terms of the register, whether the state will continue, open up its own case, especially where there are grounds that this person should have gone through the register. But because of certain outside negotiations, they find out these cases being dropped off. How do we deal with such situation? Thank you very much, Chair.
Thank you very much, Honorable Mtetwa. Okay, and I see there's no follow-up from Honorable Dudovu. I think, Deputy Minister, let me then hand over. I would imagine the question asked by Mtetwa, Mr. Dupree would respond to that.
Well, look, I also wanted to have a bash at it, and that is that firstly, the register is only for people who've been convicted. So people who are suspected are not on the register as suspects. You're only you're only on the register once you've been found guilty. There is a problem of, and you'll see it comes up with domestic violence orders as well when we deal with that bill, of particularly, well, specifically with domestic violence orders, people apply for an interim order, and basically it's a temporary order until to give the person who the order's against the chance to respond at a later point, and if not, then it gets made final. But many women go and get the order withdrawn. So it is a problem with sexual offences. Honourable Dodova also, I think, spoke about it, of people laying a charge. I mean, look, you for example, with the Thuthuzela care centres, you don't have to lay a charge to be able to use the facilities at the Thuthuzela care centre, precisely because we want to encourage people and not sort of force them. But the withdrawal of charges is a problem. Honourable Mthethwa is representing KwaZulu-Natal. There's a particular problem at Umlazi where we had 2 sexual offences courts in use, but now we only have 1, and that's because of the volume of the cases. And the court officials that I spoke to suspect it's issues of people accepting compensation and then withdrawing the charges. I think Mr. du Preez can comment more. I mean, my understanding is that it's the state that I mean, you've got the state charges and the state withdraws, but the problem is if you don't have a witness, are you going to be, or your witness is refusing to testify, are you going to be able to prove get a conviction? There is an issue in this bill that you've got where there's mandatory reporting of a sexual offence against a vulnerable person. Previously, it was limited to sexual offences against children and people with mental disabilities. It's now expanded to vulnerable people, that the category that we spoke of, that if you know that a young woman at a residence has been raped in the residence by somebody, then you have a duty to report it, and charges can be laid without them. But there's some contention, as you would have seen, around the issue of agency. So that's also something you're going to have to look at. But I mean, to my side, I mean, the more we can make the process of giving evidence, having evidence taken, and giving evidence in court, the more we can make it easier. Hopefully, the fewer people will want to have the charges withdrawn. Maybe Mr. du Preez can comment. Yeah, so let me leave it like that for now, and hope I've answered to some extent Mr. Honourable Mthethwa, and then if Mr. du Preez or Ms. Pillay can add.
Mr. du Preez or Ms. Pillay?
Madam Chair, I feel very unwanted this morning because I was kicked out once again, but I'm back now.
Okay.
When it comes to mandatory reporting, Madam Chair, there's only an obligation to report that suspicion that a sexual offence has been committed against a person. It is, of course, for SAPS to investigate that alleged offence, and they will then, of course, contact and take statements from the alleged victim. However, when it comes to an adult person is allowed and is free to do so, to withdraw a charge at any time during the course of the investigation. When it comes to the discretion of the prosecuting authority, for whatever reason, may, before, at any time during the criminal proceedings, before the accused person leaves, the prosecution is empowered to then withdraw a case against an accused person. The indication that we've received is that when a prosecutor is faced with a complainant who is not willing to testify in a case after the accused has pleaded. They take a lot of time and effort to explain to the victims, the victims, the importance of testifying in court, and also impressing upon them that it's important, especially when it comes to sexual offences, which are considered particularly serious offences, to testify in court. And from what I could have gathered is, I think the Deputy Minister referred to the circumstances being improved drastically when it comes to alleged victims testifying in court. Madam Chair, I apologize, and if my question is not answered, or my answer is not directed at the questions that have been raised, I apologize. As I said, I was kicked out the second time.
Thank you, Mr. Dupree. I think the Deputy Minister has been on the platform and he has also been responding to issues. Ms. Pillay, do you have anything to add?
Thank you, Chair. I have nothing to add. Thank you.
Okay, thank you very much. Deputy Minister, I'm not sure if you wanted to still come in, or can we move on?
Chair, no, I don't have anything more to say. It's obviously for the committee to deliberate on all the issues raised. Just maybe a quick plug, though. I mean, look, and we are saying from the ministry, from the department side, that there are some amendments necessary that we would agree with, that were sort of overlooked. It's the advantage of having a bicameral parliament. But, you know, the bill was supported by all parties in the National Assembly. We hope that that will continue into the NCOP. But that's obviously just a hope. It's your decision. Thank you, and the members' decision. Thank you, Chair.
No, thank you very much, Deputy Minister, and the entire team from the department for all your responses. Our members, I think when we got the briefing last week, we also gave an indication in terms of the urgency of these bills. But obviously, we would want to be thorough when we deal with this piece of legislation. But we would also obviously want to be efficient. So I'm going to propose then, honourable members, that if you have further deliberations and or inputs you want to make on this bill, I'm going to say that you should feel free to forward it to Gershwin for now, and we'll develop a mechanism to also try and be efficient with processing some of this information. But also to indicate to yourself that next week we will be receiving a briefing by the department in terms of their responses to the other two GBV bills, and we will at a later stage also continue further deliberating on this bill. But just in terms of also trying to efficiently move forward as well, I think there are some proposed amendments that came out through this process. And the one being in terms of clause 5, where the definition of sexual offense read with Section 50 of the Principal Act needs to be clarified so that the interpretation of the provision would become more clear. In terms of clause 6, with clause 6, I think the issue around congregate or are present, and the need for redrafting. Okay, I think what the department is saying on this one, that the provision should be redrafted, but this is linked to Section 41 of the Principal Act. Then there's the issue of persons with mental disabilities. I would propose that also the legal teams look into this matter, meaning the legal team from both the Parliament as well as the National Assembly. And then in terms of clause 13, okay, I think I dealt with that one. So there are those few clauses. Okay, I think clause 13 as well deals with the section 47(1), reference to children and persons who are mentally disabled. I think that's also an alignment issue, which perhaps the legal team should actually start looking into, just so that we try and move forward with some of these processes. But like I said, honorable members, we will leave it open for yourselves to make any other input that you would want to make. Please do it as soon as you possibly can, so that we can then try and speed up this process. I think with that said, let me then thank you, Deputy Minister, and your team from the department for making the necessary presentations to the committee, and thank honorable members of the committee for your inputs on this matter. We will meet next week, Wednesday, to look at the other two gender-based violence bills. And with that said, honorable members and Deputy Minister in the department, let me then declare this meeting closed for now. Thank you very much.
Thank you very much, Chair.
Thank you, Chair.